So we're talking today about planning for incapacity. Now, I'm an estate planning lawyer, and when most people think about estate planning, you're thinking about will or trust, you know, after they die, who's going to get their stuff. But probably the more important aspect of estate planning is what we're talking about today, incapacity. Because this is what happens when you are alive. Okay? So it may not be as glamorous sometimes as talking about big estates and wills and things like that, but it's probably more important.
Most important.
Yes. So the first thing I wanted to focus on is conservatorships. Is anybody here a conservatee? Good. Is anybody a conservator? Okay. Well, a conservatorship is very expensive. It's very time-consuming. It's a court proceeding. It's kind of, well, anytime you're in court, it's not a good thing. Okay? So I wanted to present the conservatorship part of this first because you really need to know what would happen if you don't really plan for incapacity. Because that's what a conservatorship is. A conservatorship is a court procedure that gives an individual authority to act on an individual's behalf. Okay? That person must be incapacitated. Now, there's two types of conservatorships. There's a conservatorship of the estate and a conservatorship of the person. A conservatorship of the estate means that the conservator is controlling the money of the person, of the incapacitated person. The conservatorship of the estate means that the conservator is controlling that person's physical being. Okay, so imagine somebody that can't physically take care of themselves. Well, the conservator of the person is the one who either lives with the conservatee or arranges for live-in help or nursing home help, and who actually takes care of that person physically, okay, as opposed to the financial aspects of it.
Wouldn't that necessarily include both then?
Well, yes, sometimes, most of the times, the conservator will be appointed over the estate and the person, but sometimes it's different people. Okay? We'll talk more about that in a bit. Now, the standard to be considered, this is conservatorship of the person, is that the conservatee is unable to provide properly for his or her health, food, clothing, or shelter. Okay, that's a different standard than conservatorship of the estate, which is money. Okay, to be a conservatee under that kind of conservatorship, the person has to be substantially unable to manage his own financial resources or to resist fraud or undue influence.
We had a gal who did the Nigerian lottery. I don't know if there was even such a thing as a Nigerian lottery, but she spent over $100,000, and then she was put under a conservatorship because of that. Last week I got a conservatorship. The individual had sent $150,000 to the Philippines to his new bride. He's 85. So, you know, it's there to help protect, you know, or it's just a thing about males, you know, we should never let them get older.
You know, undue influence is when somebody begins to rely on someone, usually a much younger person, but not always, and sometimes a family member, but again, not always. And they begin to rely and become so dependent on that other person that they can't resist naming that person in their will or giving them all their money. Okay, so if that's the situation, that would also be grounds for a conservatorship.
And it's messy because it's a court procedure.
It's terrible. It's,
yeah. You don't want to be there.
You talked about probate last week. This is like a probate, but even worse, because the person's alive still, and they have to be dragged into court. The judge asks them embarrassing questions, you know, like, what's your name? And sometimes they don't know.
And it's horrible. It's very demeaning.
Yep.
And then there might be somebody there on the other side saying they shouldn't be conserved, and
a lot of litigation over that.
Yeah, you can't vote any longer. It's not something that you want to get involved in.
Yeah.
And how do you stay away from the conservatorship?
Well, we'll get to that later.
Okay.
Now, with the conservatorship of the estate, if the person is really, incapacitated, they can be granted special powers to put the person in a locked facility, basically. That's if somebody's got Alzheimer's, they wander out, it's kind of a dangerous situation. So the conservator can actually make sure that the facility has a secured perimeter. And also to administer psychotropic medication. Okay, these are special powers that the conservator must ask for in court.
What's the difference from being a conservator and a trustee?
Not much, and we'll get to that in a second.
That's a really good question. We're going to talk about how to avoid the conservatorship.
And that's being a trustee. It's private versus this is public, is essentially the answer.
So, sticking with conservatorships just for a couple more minutes, who can be named conservator? Well, a family member can be a conservator, a professional fiduciary like Peter can be named as the conservator. The public guardian is a conservator over people who don't have family members or friends and who don't choose a professional fiduciary. They don't have anybody else. So Orange County has a whole public guardian's office that does this.
And it's absolutely a nightmare. It's swamped. There are so many people.
The court will also look to see if the proposed conservatee ever appointed anybody as their own conservator. And that's probably one of the best things to do in a separate document done ahead of time. So one of the ways...
What document do you do that in?
The healthcare directive and the power of attorney, okay? Which we'll get to in a minute. But in those documents, you say, hey, look, if there's ever a conservatorship for me, I appoint this person to be my conservator.
Because sometimes there's a fight in the family who's going to be the conservator. And you don't want that. And so you get to name the person in these documents who's going to be that.
Right. So the main thing about conservatorship that you should know is how to avoid it. It's not a good thing. You don't want to have a conservatorship.
And so what's the best way to avoid it?
Well, you should have several documents prepared ahead of time. So you never know if we're going to have dementia, or if we're going to have stroke, or we're going to have Alzheimer's, or anything like this. So you need to plan for that ahead of time. One of the documents is a power of attorney for finances. The other one is a healthcare directive, or an advanced healthcare directive, and a living trust also. Okay, so those three things will help avoid a conservatorship. Now, the power of attorney for finances is a separate document, the purpose of which is basically to do the same as a conservatorship. Remember, conservatorship is for people who are incapacitated, who can't manage their own finances, right? Well, that's what this document does. But it's signed ahead of time. So you're naming somebody as your agent to make financial decisions and actions on your behalf. That's what a power of attorney for finances does. There's two general types. There's a durable and a non-durable. This is very important. A non-durable power of attorney is not what we want. Non-durable means that if you're mentally incapacitated, the power of attorney is not effective. Okay? So that defeats the purpose. What we need for purposes of planning for incapacity is a durable power of attorney.
So when do we use that non-durable?
A non-durable, well, for those here that might not have heard it, when would you use a non-durable power of attorney? That would be used for other things like you're leaving the country for a couple of months and you have some business to take care of, so you're going to name your accountant or your son or daughter as a temporary agent for you to take care of that. The next bullet point is a general versus limited. General power of attorney means that person can do anything that I would be able to do myself. Okay? A limited power is one where you say, you know what, I don't want to give this person so much authority. I want Peter Coe to only manage the sale of this particular condo. Okay? But nothing else. Can't handle my bank accounts, can't do anything with the retirement accounts, nothing. Just that. That's a limited power. But what we're talking about for estate planning is the durable power of attorney. And many times, most times actually, we want to have that be a springing power. I'll explain the difference. When you sign a document, usually, you know, it's effective after you sign it, right? You execute the thing, you notarize it, boom, it's in place. But a springing power of attorney doesn't really have any effect until a later date, and it springs into effect when it's triggered by a certain event. And for our purposes, for planning for incapacity, what do you think that event is? Yeah, incapacitated, right? So you sign it now, you name somebody as your agent, but in that document it says that this document, this durable power of attorney, is only going to become effective if two doctors examine me and determine that I'm not able to mentally handle my own finances. And if those doctors sign certificates to that effect, that's when this power of attorney springs into effect, and now you're protected from the conservatorship. Well, I'll tell you, Peter, you know, I go back and forth on this a lot.
Yeah.
And, you know, with my clients, it seems to me that the younger ones don't really feel very comfortable giving the springing, giving the immediate power. They don't want to give their son or daughter authority over their bank accounts right then and there. They don't want to give up that much control. The older people get, the more they favor the...
Now, I would never give this to my son. Or my daughter. I know, I would never give this to him. You may run off to Vegas and, you know, say, hey, I got my dad's immediate power of attorney, get into my account, and everything else. I would never give it. I would always give it to a third person. I would hide it with my rest of my documents. But I think I'm leaning towards immediate, at least this stage.
I've been doing a lot more like that.
Yeah.
If you present them, or if your agent presents them with a power of attorney that's 5 years old, they may not honor it. They may say, you know, this is too old. We want one that's within 90 days sometimes, or at least a year. Sometimes you don't have a choice, though.
Yeah.
Okay, like if they had a springing power of attorney and then they become incapacitated, well, now they can't sign the bank's form. Okay? And by law, the bank has to honor a valid power of attorney. Even though they say they don't, they have to.
You need a power of attorney if you have a trust?
You do. Brian, you want to answer that?
You should, because the trust is going to be good for those things that are titled in the trust. But, like Peter just mentioned, there was a bank account for this one person who wasn't in the trust.
It was in her own name.
That's why you need the power of attorney. You also need the power of attorney for other things, you know, like filing tax returns,
IRAs,
retirement plans,
401ks.
and those things aren't typically in your trust, see? So you need both. You can go to a stationery store and buy a printed form, right? Or go to LegalZoom or one of those. The state of California also has a statutory power of attorney. It's in the probate code. Okay? Then, of course, lawyers draft these things. And when the lawyers do it, you know, we put a lot of stuff in there. We try to make sure that every possible thing is in the power of attorney. So I prefer that. And then there's a combination. So when I draft a power of attorney, I'll take sections from the statutes and other things that I like put in there and have in the document and make a nice combination.